We also look at for getting started with a little bit of the background, which I'm sure many of you are already familiar with what Lido is. The forest is based in a conservation area and it borders on Orange County and Osceola County. We looked at specifically the Osceola Parkway Extension Project, kicking off in 2017. CFX began conducting its concept, feasibility, and stability studies, which looked at their master plan projects. As a part of that was the plan to extend the toll road in Osceola, Orange, and Polk County. We also looked specifically at, the fact that despite the designation of Lido's conservation area as intended to permanently protect the forest from future development, Lido now faces imminent threat of development with agreement between Osceola and CFX supporting acquisition of this land to use for the toll road extension. The parties in this matter focus primarily on Orange County, Osceola County, and the Central Florida Expressway Authority and the planned development of this. Taking it back to the beginning, we looked just again at the timeline of events that I'm sure many of you are familiar with. Starting in 1991, the agreement between Orange and Osceola counties to form a partnership in order to place Lido Forest into conservation land, bringing it through towards the dispute between Orange and Osceola County, where following Orange County's vote to amend the charter to protect that land, Osceola brought suit against that. That action in which the matter went all the way to the 6th CPA, which affirmed the lower court decision that the charter was not void. Which brings us to the present matter now. In 2026, this year, CFX submitted their written offer to Orange County for acquisition of Lido and Eagle Root. The commission voted to reject that offer, and CFX has now filed a petition for eminent domain. And we got it. Out.
Can you hear?
You guys?
Yeah, it mutes. Not working.
Hello. Okay. Hello. Okay. Back off. Orange County filed its answer in response to that question. Yeah. And then I will put it off to Ashley to cover the specific action associated with the semester by CFX. All right, guys.
So,
recently we kind of looked at things. So the first thing that we looked at was the January board meeting. We also looked at other board meetings regarding CFX, and we also looked at a memo regarding order of taking. Just to sum it up, because in addition to me, my friend Ishtar is also going to continue doing the other two parts, but for the January 13th meeting, we did look at the county attorney, where they basically stated that the Orange County is the inferior entity. And we also looked at the charter conflict, which talked about a state delegated power, which likely preempted the 2024 voter approval charter amendments for the conservation. Another thing is the political mandate, which I will go further into the next slide. For the other board meetings, like I mentioned previously, we looked at any board meetings that CFX had actually spoken to. So a couple of the things that they mentioned were the CFX proposal for the 1,500 plus acres and the $13 million in management funds. Another thing was the sideline authority. So Osceola County state agencies are proceeding without Orange County's consent, which is one of the biggest issues that we see with the current case going forward. And the transparency gap. So critics argue that CFX failed to explicitly name specific parcels like Eagles Roost, which is also, if you guys are up to date with the current case, one of the big arguments that we have there. And the other thing that we looked at was the memo regarding the order of taking, as previously mentioned. So we looked at the procedural complexities, which is CFX completed appraisal, which is estimated to be about 2.4 million. That was their original offer. And another thing was the quick take process, which CFX is currently trying to take control of Split Oak and Eagles Roost, and the CFX asserting the superior authority under the Florida statute at 384. So in regards to the January 13th meeting, as I previously mentioned, one of the biggest things was the Orange County attorney defining themselves as the inferior entity to CFX. So under Florida statute 348, CFX statutory mandate builds regional infrastructure legally supersedes local county protections, which just basically saying that they're trying to claim that the highway is more important than Split Oak. The establishment of public purpose, which kind of goes back to what I just said, they're challenging the necessity need of a requirement, the necessity need for the Split Oak versus the highway. So they're basically saying that the highway is needed more than Split Oak itself. Another thing was the preemption of local charters. So despite the 2024 voter approved charter amendment to protect the conservation's land, legal briefing suggests that CFX state delegated sovereign power likely to preempt the local home rule. And the final thing was the board's decision. So the board decided in a 4-3 vote that they choose to reject the meeting and hire outside counsel, which is what is currently happening right now. And with that, I will give it to.
So an important thing to focus on when it comes to the historical aspect of CFX and the evolution of their projects is that CFX has proposed a mitigation package that has included more than 1,500 acres of new conservation land, around $13 million. Now, CFX's position is that alternative routes were considered to avoid the forest entirely. However, they ultimately rejected this position because they weren't the safest option for regional traffic flow, they stated. Since 2024, Osceola County and other state agencies have moved to satisfy the project conditions independently. which CFX has argued has reduced Orange County's effective veto power and third-party legal standing. Now, when it comes to transparency for this, although different maps were available as early as 2019 to CFX did not verbally identify or disclose any specific targeted parcels of land, including Eagles Roost, which we didn't find out about until much later in the process. So now moving on to the memo that was put out in regards to the order of takings, the acquisition process. Now, CFX has taken a formal process steps under Florida Statute 73.015. And after the board had declined to negotiate, CFX continued to state that they plan to file an eminent domains actions by February 9th of 2026. With an order of takings that's expected to be heard in the late spring or early summer. Now, under Florida law, CFX maintains that construction can continue under good faith. However, they also argue that specific legislation gives them the authority to acquire public lands, parks and reservations and conservation land. But this language, it overrides the common law protections for conservation. So with that, we're going to move on to the eminent domain aspect.
You hear me now? Okay, perfect. Looked at specifically Florida. There are 2 chapters. You guys hear me? There are 2 chapters in Florida. That's it. Relevant. Those are chapter 74 and chapter 7. Essentially, eminent domain, that is the power of the government, delegate us to take private or public property, public use, provided receive. CFX utilizes the quick take method. Chapter 7. This allows them to take in while pending final on the compensation. This power is actually the battle that we have going. And it is regarding specific of CFX at Oak. Status of the eminent domain being by CFX follows a sort of neat timeline of January 13th here is where the eminent domain process technically did by CFX, where they transition faith offer, and that kicks off the timeline for the required to follow by the so in that they made formal offer and Orange County rejected the settlement. The primary defense being mounted by the county involves challenging the necessity of the taking, specifically pointing out that Split Oak was discussed in 2019, but Eagles Roost was never disclosed to the board, essentially invalidating good faith. Orange County also highlighted the value of the discrepancy, noting that they purchased Eagles Roost $8.5 million in 2006, and that's nearly 4 times what CFX is actually offering that parcel. So that further supports a defense against the adequacy and offered good faith offer. In order to ensure the adequate defense and avoid implement, the mayor moved to permit outside counsel to head up the on CFX matter on behalf of. Also, in our research, looked at specifically available defense. Now, we reviewed essentially a petition, what CFX is, as discussed earlier, looked at the superior doctrine, which states that because CFX is a state authorized of the power to override the that establishes the public. However, in this case, the argument is that they're arguing public against public, or at least already. So it comes down to the necessity of all that. To discuss the facts that or
Yeah, so what we see here on this slide are just 4 main contractual agreements that we looked at for the semester. There's the 1994 agreement, and there's the grant award agreement, the amendment, and then the management plan. And what I really want to talk about are just the primary contractual provisions that are included within the 1994 award agreement. Yeah, that's. So the first provision is that conservation and public use mandate. And basically what this says is that the land is to be exclusively used for public use. So it has an exclusive use for conservation, protection, and enhancement of natural and historical resources, and for passive natural. I don't know if I can. Are we good now? Okay. So passive natural resource-based public outdoor recreation consistent with the Florida Conservation Trust approved project plan. So any breach of public use is gets into the next. Okay, I'll try this again. So really what this gets into the next point, which is the primary main point for all of this, and that there's a reversionary interest. So if there's any kind of breach in the contract, whether it be by Osceola or Orange County, the fee simple title awarded to either side reverts back to the board. And I know we haven't seen that occur, but that is what's listed out in the actual contract. And so in this case, the 1994 agreement, it specifically addresses governmental takings, and Orange County as a board recipient, in the instance where there is a taking, it must deposit any of the condemnation award with the board. And I think we can switch slide now. So the next one is that there's oversight and approvals required. So any transfer, this includes condemnation. It could be new construction, tree removal, major land alterations, or any kind of private use that requires written approval by the board. And moreover, they actually retain inspection rights and annual reporting requirements. So in this case, the eminent domain action and any post-taking changes to Split Oak site. I guess so. So any kind of changes, what they're going to do is they're going to trigger a default or a loss of tax-exempt bond status. Then the next point is public access and identification. And so what that states is that the site must remain open to the public. All signage, literature, and advertising must clearly identify it as publicly owned, funded by the FCT preservation bond. And so what that means here is that condemnation and conversion of parkland into highway use, what it's going to do is it's going to violate the public access and the identification covenants unless fully mitigated and restored per the agreement. And then the final contractual provision is the bond and tax compliance amendment. It's the 1994 amendment. I don't know if it's because I have to keep leaning over. So this has strict limits on private leases, concessions, sales, or non-public uses to preserve tax-exempt status of the original bond. The 1994 amendment excluded specific parcels from mitigation fees and easements, but it left the core conservation restrictions act. And so what that means in this case is that CFX is must comply with these bond-related restrictions, or they're going to risk jeopardizing the original tax-exempt finance. So, done. Okay.
It look what we looking at legal and procedural support, we would say, to request evidentiary support of the underlying case, and that can either be by discovery by the county or public information request directly to CFX. It also looks at exploring intervention possibilities, whether that be by individuals that might have standing to do so or community interest groups that might have, again, the necessary standing to, or by amicus filings if that's, permissible. So that would be something that we would suggest looking into as a continued effort as a way to involve more members of the public in the action, and give more for CFX to really respond to. And again, to just continue the advocacy efforts that both the county commission's office and the league have put forth on looking at more public awareness and education, partnering with more community associations, and, where possible to just, again, remind the legislature that, we're requesting involvement. This involves an important question as far as they're concerned about the superior authority and how that works with public use for public use. That wraps us up and brings us of Split Oak. Can you hear me? Yeah. Okay, moving on to the next matter we looked at this semester. It was a review of a prior matter that we had. And this was looking at the Lake Pickett Borrow Pit. So this semester, we reviewed the matter and the issues. We looked again at the timeline of actions that had been taken so far and updated actions. We also looked at a more in-depth review of what actors were present and what authority they had to actually regulate the borrow pit operations, and then what process and materials are actually involved in the borrow pit operation, as well as what harm or damage was actually involved to the environment as a result of these borrow pits. Just as a matter of quick review, the Lake Pickett Borrow matter was a continuation. The clinic's work this semester focused on issues in key areas of concern stemming from these operations located on Lake Pickett Road in Orlando. And these are owned and operated by James Mead through various entities that he has located at this premises as well as another one. The ongoing operations are a matter of community concern for a number of reasons, primarily including the environmental threat that they pose, as well as the lack of action been taken to regulate. The big issue is us trying to work to see, how can we look at the enforcement gap and what can be done here. Although the Florida Department of Environmental Protection has taken some action through regulatory steps and the active litigation, the matter remains ongoing and the, operations continue despite the ongoing action been taken. Looking at that, we have, of course, underlying litigation that's involved, and that is an active case that is in the 6th PCA currently, pending on appeal. The operations, again, are still continuing, despite the fact that there are several options for enforcement, and there are concurrent authorities that can take action for enforcement. Again, just looking at a general timeline overview of the Lake Pickett Borrow Pit matter. In 2012 was when Mead shifted his operations from a composting operation to transition to the materials and the operation we're working with today. Moving through 2016, he filed his petition for an administrative hearing following notice from the FDEP that he was out of compliance required to comply with their statutes and permitting requirements. In 2017 is when he actually began his operation on Lake Pickett Road. He also has another building facility that he runs. In 2021, they held a hearing in the lower court case about the enforcement action that FDEP filed. And FDEP was, successful in that case. However, they were required to file in the 9th district in order to enforce the order of the administrative court. In 2025, the final judgment was ordered in that, which was appealed then now to the 6th DCA where it sits currently. In that action, they had mediation, which was unsuccessful, and both parties have filed their initial brief and reply, and there is an oral argument set for 3rd currently in the 6th DCA on that matter. Specifically this semester, we did a deep dive into the actors and authority here. We looked at 4 primary sources of authority for regulating borrow pit operations, looking at the Florida Department of Environmental Protection, the federal authority, Orange County, and then the St. Johns River Water Management District. These authorities are grounded in different legal frameworks and trigger at different thresholds, but they're not mutually exclusive. Multiple agents should and could be acting simultaneously to take regulatory action of the borrow pit. I am going to turn it over to discuss the federal actors and authority that we explored.
Florida's wetlands and waterways are regulated by 3 key players under the Clean Water Act, Section 404, the EPA, the Army Corps of Engineers, and Florida's own Florida Department of Environmental Protection. Since December 2020, Florida has taken over permitting for most of its waters, including smaller rivers, streams, lakes, and wetlands, called assumed waters. And through the FDEP, the Florida Corps retains control over major navigable waters, such as St. Johns River, known as retained waters. The EPA never fully steps aside, and it jumps in when projects affect specially protected wetlands, which are declared special case, or proceed without any permit at all. When the EPA acts, it can issue stop work orders, fine up to $187,500 per violation, and seek court injunctions and even pursue criminal charges.
So there are really 3 sources that the Clean Water Act supervises over. So First, we have the point sources. So National Pollutant Discharge System, the Sorry. So the NPDES core program for control pollution. The NPDES relates discharges from point sources, which are defined instances, pipes, man-made ditches, tunnels, or containers. Industrial wastewater sources are caused by factories, including factories for chemicals, electronics, and automobiles. Municipal wastewater sources are publicly owned treatment works or sewage plants that are regulated to ensure human waste is treated before being released into rivers and streams. Non-point sources are also covered under the Clean Water Act, and they handle non-point sources differently than point. While point sources are strictly regulated through a federal permit system, yes, non-point sources are generally not regulated by the federal government, same sense of requiring a discharge permit. Instead, the CWA uses a non-regulatory grant-based approach that requires states to identify and manage these sources through best management practices. And then finally, Waters of the United States must meet a relatively permanent standard. Defining WOTUS is critical because it determines the scope of the Clean Water Act. If a body of water is a WOTUS, it is federally protected. Activities like discharging pollutants or filling in wetlands require federal permits. If it is not WOTUS, regulation falls primarily to the states. As of 2026, the definition of WOTUS has been narrowed due to decisions in court, such as Sackett v.
FDEP next.
Yeah.
The other agency that is currently involved in litigation with Mr. Mead is the FDEP. The FDEP, they're the primary state regulatory authority, and they carry the broadest authority over the Lake Pickett Borrow Pit operation. Their authority flows from these three overlapping statutes that we have listed green here. Chapter 378, which is the land reclamation statute, and that requires operators to obtain a mining permit and to submit a reclamation plan ensuring the land is restored post-excavation. Chapter 373 is the permitting requirement, which governs environmental resource permits and water use permits, any alteration, wetlands, floodplains, or water bodies that requires the FDEP authorization, which includes a direct hook into borrow pit dewatering operation. And then finally, Chapter 403, which is the water quality provision. And what this does is it prohibits unpermitted discharges of pollutants and stormwater runoff. It is the P. And stormwater runoff drawn down from the pit operations are regulated here. So violations, these can carry both civil and criminal penalties. And the FDEP has the broadest authority out of any of the agencies that we're looking at it in regards to Lake Pickett Borrow Pit. And they are the lead environmental agency by constitutional and statutory design. So unlike St. John's River Water Management District, which is just limited to water resource management, U.S. Army Corps of Engineers, which is limited to navigable waters or wetlands, or the Orange County EPD, which is a delegated local program, the FDEP holds concurrent, overlapping, and independent authority across every category of violation present at this site. So that includes mining, water quality, solid waste, and wetland protection, meaning it does not need to coordinate with or defer to any other agency.
So the county that we all love, Orange County. Orange County has direct local authority over all land use, excavation, billing, and mass grading. And it can use that authority to address nuisance and environmental harm from the borough pit operations.
We're good to check.
We're good. The county's role is different from state agencies because it controls the zoning and determine whether the activity is truly a bona fide agricultural use or instead a commercial operation that conflicts with the comprehensive plan. Florida statutes also strengthen the enforcement pathway by requiring ordinance violations to be prosecuted as misdemeanors, which gives Orange County a concrete mechanism to move beyond just passive oversight. The county also has a reclamation authority, meaning that it can require distributed land to be restored to a safe, stable, and usable condition after excavation or mining-related activity. St. Johns River Water Management District is the key to regional water regulation. For this issue, its jurisdiction includes the Orlando metro area, and it is charged with protecting water supply, water quality, flood control, and natural systems. When it comes to borough pit excavation in Florida, this raises a major groundwater concern because digging often reaches the Floridian aquifer, making aquifer protection, hydraulic impacts central to the Florida district's authority. Now, St. Johns River Water Management District issues environmental resource permits to ensure excavation does not damage wetlands or pollute surface waters or increase flooding risk. A major concern here is enforcement failure. When excavation continues despite a stop work order, this leaves the district unable to verify whether the aquifer's confining layer has been pierced or not. And the environmental stakes are high because uncontrolled excavation may disrupt groundwater pressure, reduce base flow in the Econ River, increase localized flooding, and allow sediment or toxins to enter nearby waters. Now, an overview of the borough pit. A borough pit is simply an excavation site where soil, sand, gravel, or clay is removed for use to fill material somewhere else. Its primary purpose is to supply fill dirt for roads, levees, and other construction needs. In Florida, borough pits are heavily tied to environmental regulation because they often dig below the water table and can become a man-made lake or pond. And just a key point of this is that contractors on state projects, they cannot use borough pit material unless an operator certifies compliance with the environmental standards and holds valid permits from the Department of Environmental Protection, relevant water management under Florida statutes.
Specifically for the environment that the environment faces from these borough pit operations, we looked at what the borough pit operations are actively fighting regulation and they're claiming a blanket exception from permitting, evading discovery of materials and practices that are involved in the borough pit, which makes it very hard to actually determine what harm can come from this when there's exemption and evading disclosing the materials and process that are involved in. Looking at it though, one of the primary threats that the environment faces is the obvious groundwater contamination and pollution of the Econ River from these illegal waste operations. And that is the paramount concern in this case, especially because Florida's high charge geology contaminants in the borough pits, they migrate rapidly into the Florida aquifer, the primary drinking water source for millions of Central Florida residents. The Econ River flows through the preserve, and it contains numerous flatwood pines, cypress domes, cypress sloes, and freshwater marsh habitats. These unpermitted excavation in close proximity to this freshwater system causes sediment runoff, altered drainage patterns, and nutrient and chemical loading, all without the stormwater controls that you would ordinarily be impacting and regulating. Essentially, burying the yard waste and other materials that are in the borrow pit without a solid waste permit violates statute 403 and Orange County solid waste ordinances, and it creates risk. Looking at the byproducts entering the soil and groundwater. Looking specifically at the borrow pit operation. Looking at the borrow pit operations, we looked at the approvals and regulations required, the site and prep disposal. We also looked at excavation rules, testing and quality control, and reclamation. Looking at essentially what is required for most borrow pit operations. Specifically in this case, we're able to uncover the patent that was applied for by the operator of this borrow pit, which did give us some insight into the process that's being.
Yeah, and so what this patent kind of lays out is first, what occurs is there's an excavation. And one of the things that's interesting about the patent is, this might be something worth looking into in the future, is it does not state in there how deep they're supposed to dig. Just that they dig, and they don't say this, but they pump out the water. So as soon as they hit the water table, put a sump pump in there and start pumping out the water. So we could look into what happens with the water that's being pumped out and whether there's other runoff or damage that occurs just from the excavation itself, because it doesn't state how deep he's digging, just that he's digging and then he's pumping it out, but he's filling it back in with what he calls, or excuse me, what the patent states is it's inorganic residues, which create anaerobic conditions that permanently sequester carbon and nitrogen while keeping the land in an agricultural production. So what he's stating is that this is actually a form of carbon sequestration so that it's environmentally friendly. And I kind of already went over the step-by-step process. And so it also states that there's environmental and economic benefits to it, and that it turns the low-value wood or forestry waste into long-term carbon sink, which sequesters nitrates, generates new farm revenue from carbon offsets, wood handling fees and soil fees, low-tech, reversible, and serves the farmland use. Then those.
Just to quickly wrap it up, we looked at what to look at in the next coming months. That is the oral argument set for June 3rd, working to identify actual harm, as well as questions of current permitting, and planning for fall, looking at federal authorities and delegation to the state and possible Orange County enforcement proposals.
Okay, so this semester we were asked to look at the legislative tracking. I'm going to review with you the Florida legislative process, some key details, which bills we were tracking, and their current status. So, quick overview: in order to pass legislation, there has to be a first reading, which is an introduction and referral to committees for analysis and public hearings. Second reading, floor debate and amendments, and a third reading, which is final roll call vote, usually occurring on a separate day from the second reading. A little bit about the details is that the legislator has 40 senators, 120 representatives. The session usually lasts about 60 days, and the bills must generally clear committees by week 5 or 6, or they're effectively dead. And then the path to enactment and public advocacy, I already reviewed with you the 3 readings. There's opportunities for public advocacy. The league can use these nonpartisan documents to understand the fiscal and legal impacts of a bill without needing to decipher the complex legal jargon. The citizens can provide public testimony around 30 to 120 seconds for or against a bill of its committee stops. And all meetings and floor sessions are broadcast on the Florida channel. And if the legislator refuses to act, Floridians can bypass them by gathering signatures for a constitutional amendment, which requires 60% voter approval to pass. There's some specific constitutional limits, the single subject rule, special versus general laws, and prohibited subjects. Then once we get to the governor's desk, once passed, the governor has 3 different choices. They can either sign, veto, or ignore. If they sign it, it becomes law. If they veto it, it's returned with objections, and the legislator can override this with a 2/3 vote in each chamber. And if ignored and not signed or vetoed within 7 days, 15 days if the session is adjourned, the bill becomes law automatically.
Okay, so we identified 11 bills which were potentially relevant to the issue important to clinic matters. A very abridged version of those 11 bills are as follows. HB 167, or the former Phosphate Mining Lands Bill, proposed to set legal conditions for phosphate mine sites and requires DOH radiation surveys. SB 686, or the Agricultural Enclaves Bill, allows for landowners to apply for agricultural land certification for commercial, industrial, or residential development. SB 208, or the Land Use and Development Bill, capped application fees and added residential and compatibility rules and allowed for off-site built homes. The Blue Ribbons Project Bill proposed a special Blue Ribbons designation, which would be a new designation granting max density or non-residential intensity for qualifying projects. The Housing Bill mandates ADUs in certain areas and studies tiny homes as well as mezzanine financing. The Land Use Regulation Bill was a bill of definition, and it defined the authority of impacted local governments. The Data Centers Bill was interesting. It regulates very large data centers, so those that constituted the size of using as much power as a small city, in which they would have to pay their own electric costs, and it blocked foreign adversarial ownership, amongst other things. The Post-Disaster Land Use Bill blocked disaster-hit localities from enforcing
moratoriums or changing rebuild rules. The conservation easement bill requires release of easements under certain conditions to allow for development. The local enforcement actions bill proposed limits for county and municipal enforcement and creates legal remedies for those affected parties. And finally, the land and water management bill provided for state preemption of water quality, pollution, and wetlands regulation. So of that long list of bills, 3 of those passed by the end of the session, and they were the former phosphates mining lands bill, the data centers bill, and the agricultural enclaves. 2 were substituted or held and stalled at the end of the session. They were the land use and development bill and the Blue Ribbons project. And the rest of that list died or failed by the end of the session. It's important to note that just because they died at the end of the session doesn't mean they won't be reintroduced in the next session. So they will remain on our list as we go into the next semester for the clinic as bills we're going to continue to.
So again, she reviewed the current status of the track legislation that we reviewed this semester. And as a summary of our findings, the 3 bills that are what are left standing. Looking at specifically what can be done next is to essentially know the landscape and stay informed on active matters, monitor and describe to the legislative tracking resources, continue tracking what's offered as proposed, and follow up on the proposals and discussions on hot topics for insight on what might be brought back up in sessions. Again, looking at continuing your already, practiced advocacy efforts, working to engage directly with the legislature, write, call, email, look at attending advocacy events as they're available, and register and volunteer as advocates and with organizations or to partner with certain organizations. And educate and mobilize to work with to make sure that they're aware of what's going on in the legislative process. We also provided a lot of the resources that we looked at so that they were compiled in easy to disseminate, fashion, so that you know where to go to find all of the information we pulled it from.
Okay, so last semester I worked on the dioxane contamination issue in Sanford, Florida. We're going to be continuing the review of this as well. So today we're going to be talking about where we left off, review of matter, litigation, middle district case updates, federal case settlement and compliance requirements, important deadlines, and next steps. To recap the Superfund designation research, the I-4 dioxane contamination site in Sanford has not been designated as a federal Superfund site. Our research examined both the benefits and the drawbacks of that status. Potential benefits of Superfund designation are stronger federal oversight, access to dedicated cleanup funding through CERCLA, and enforceable long-term remediation timelines. Potential drawbacks would be longer designation timelines, increased administrative complexity, and reduced local control over the remediation process. Understanding the absence of Superfund designation helps clarify the city's option. The underlying litigation, to recap, we looked at 2 cases last semester, and we followed up with those cases this semester as well. The first case is the City of Sanford versus the General Dynamics Corporation. This was originally filed in Seminole County Circuit Court. This case was removed to federal court October of 2024. The city would like to hold General Dynamics, Siemens, and Money Holdings responsible for I-4 dioxin affecting the water supply. The case is currently active and the clinic continues to monitor it closely. The second case is the U.S. versus General Dynamics Corporation. It's a federal CERCLA enforcement action and is now closed. A judgment was filed on August 19th, 2024, which required the defendants to perform remedial cleanup following the EPA-approved planning and design processes and reimburse past and future response costs.
Looking at what's new from this semester, we looked again at both of those cases following along. The first one being the City of Sanford. That is still currently proceeding in the Middle District. And we are looking at the docket for new filings and developments. For the consent judgment with the U.S. case, this actually includes terms for the remedial action. And we've got some important deadlines and dates that we looked at there. For the City of Sanford case, looking at summer and early fall dates, they have expert reports and discovery that should be concluding here soon. And then all of the other motions that will be due in order to get them set for trial will be due by February 5th, 2027. So moving forward after that into trial in the matter. Looking specifically at the consent judgment, that still does have outstanding deadlines that that Siemens is required to follow as a part of their settlement. So we're looking there, the final remedial plan has not been concluded. So they are still required to file annual reports on the progress there until that's completed. So we're looking at that coming up in August of this year. And then again, they have other deadlines post that are triggered conditionally based on when that final project is completed. They'll be able to do, or they'll be required to do every 5-year periodic review. Looking at next steps for this matter, we're just going to continue tracking with the 2 court cases and the consent judgment status. You can, again, act as advocates supporting proposed legislation concerning these materials and their impact to the environment. Looking at support in the actual continued litigation as far as amicus filing are available, and then conduct continued public outreach and advocacy to make sure that people are aware of proceedings and how it affects them individually. All right, we looked again at the Seminole County Floodplain Management Plan. The 2025-2030 plan was a draft plan when we looked at it last semester, and it was formally adopted in October of 2025. So this document is the active governing document for floodplain mitigation planning through 2030. Just a quick review and recap of why the plan matters is that it looks at the CRS credit rating system and provides essentially the plan of action that the county is going to follow with respect to floodplain management. The plan looks at several goals overall for mitigation, looking at reducing the vulnerability, building disaster-resistant communities, protecting critical infrastructure, and developing supportive policy regulation planning. The actual floodplain plan itself breaks up its recommendations for the county actions into 6 categories, looking at the preventative measures, property protection measures, natural resource protection, emergency preparedness, structural project measures, and public information measures. This semester, we focus on 3 key areas of the floodplain management plan, and that was the minimum standards and the CUP growth, addressing the gaps in management and enforcement that are present in the plan, and then how the community can be involved in ensuring enforcement of this plan.
So firstly, what is the minimum standard and the CUPs? So what is the minimum flow and levels are legally established threshold under the chapter, Florida's chapter 373. So basically, under Florida law, it says that if a withdrawal would drop a river or a lake below the MFL, that permit cannot be issued. It also applies directly to major water bodies such as like the St. Johns River, the Wakiva River, and the Lake Jessup, all managed by the St. Johns River Water Management District. But there's also an issue with the new permits or the CUPs, where they're being justified based on projected population growth, not actually sustained supply. So we have a system where growth projections are pushing demand up while the MFLs are supposed to cap withdrawals. For the gaps, two main things is the permanent compliance leverage, where counties cannot issue a building permit under the FDEP or the SJRWMD. Permits are in hand. That is a hard requirement and not discretionary. The 50% substantial improvement rule is legally binding. Any repair improvement at above 50% of market values triggers full current compliance. Another thing is the structural informing gaps. So the firm maps are from 2007. The plan admits the county's flood footprint and has changed due to development and climate, yet development is still reviewed against outdated flood zone designations. The outside of the WRPA and the econ overlays a lot, and it may build even if the entire parcel is wetlands. The avoidance here's hierarchy is policy preference, not as absolute legal bar.
We also looked at the wetland permitting obligations, and so we placed those into 2 categories where the county has an absolute obligation to act and where they have the discretionary authority obligations. Looking at the Wakiva River Protection Area, there is 0 wetland loss permitted, so that is an absolute obligation. That exists also in the econ corridor as well, where no development within 550 feet of the big and little econ channels except for passive recreation. And then we also looked at the state FDEP and St. Johns River Water Management permitting requirements. Those are firm obligations. Outside of that, the county has more discretionary authority to act in those, outside protected overlays, looking at the avoidance minimum mitigate hierarchy again, and the county's comprehensive plan for conservation also impacts that as well as the wetland boundaries being confirmed by on-site review. That's more of a flexible obligation. Looking specifically at community enforcement actions, that was one of the big questions that was raised. So a few of the things that we identified that the community can do to stay engaged in enforcement action with respect to the floodplain management plan is to work with the building division or code enforcement and actively report the information that you're seeing where you find something is out of compliance. Requesting special magistrate hearings. These are held second Thursday of each month. So if code enforcement fails to act on a valid complaint, the magistrate process is the next escalation point from there. Also looking at state agency complaints, so looking at the FDEP for wetland fill or water body impacts, and then the St. Johns River Water Management District for the CUP violations or MFL threat limits. So reporting directly to those agencies when you're finding actors are out of compliance. Now, if it is those actors that are not acting, then you're looking at Chapter 120 administrative hearings and petitions under that. You're also looking at Florida statutes 403, which is the citizen suit provision, bringing civil actions for injunctive relief there. And then you're also looking at the FEMA or the National Flood Standard complaint. So if they're out of regulation and they're systematically failing to enforce the NFIP requirement, a complaint to that agency brings in their regulatory authority to oversee the CRS activity and the credit rating. And so it brings their attention and requires the county to follow these plans that they've committed to in their floodplain management. Additional areas for community involvement, we highlighted some of the key requirements and questions to ask these officials, looking specifically at when the last FEMA CRS credit audit was conducted. And then some of the ongoing engagement opportunities are that FMP progress report, which is due October of each year, and it is public, so it can be requested and respond with public comment to that if these commitments are not being met. Looking at the working groups there that they've established with respect to the floodplain plan, as well as the St. Johns River Water Management District meetings on the rulemaking. They have public comment available for those. The Board of Adjustment also has an upcoming meeting, and they hear variance requests and other things that, shift from the standards. So any variance has to be approved, and there's an opportunity for public impact there. And then there's also the Acquisition and Restoration Council meetings, which reviews the land conservation priorities. And so it can be impactful for working with conservation efforts and building in the floodplain plan. So that's another opportunity for community involvement. As far as next steps, we suggest these following, asks of the county officials, requesting the progress report and confirming it's been submitted to FEMA, asking when Seminole County will request the firm map update, which is important because that's a more local map versus the FEMA map. So it gives a more accurate reporting of actual flooding impact to the local area. And then you're also going to want to request documentation from the FD and the St. Johns River Water Management District regarding any of the permits and on development or that are involving areas adjacent to wetlands. And then asking the Board of County Commissioners to formally adopt certain recommendations, including the 2-foot freeboard standard as code and not just as a recommendation. And that goes for a lot more of the recommendations that you see in the plan that are not firm obligations, would be to, request that the board formally adopt those as resolutions. Thank you.
Okay, so those are the topics we were on. So, and then we're going to open it up for Q&A on any of the cases to look at after.
So Split Oak and Eagles Roost, do not all Orange County residents have standing because we are all harmed when a toll road goes through the forest? And Eagles Roost was never mentioned until just a few months ago. It was the first time that came up. So don't we all have standing? Can't we do a class action suit and sue CFX?
That is not something we actually at as in depth this semester, but outside of matters that. But we did, make that suggestion. That would be next natural step as far as what is required for individual members of the community, or like you suggested, a class action involvement. If that sort of action would be permitted in domain chapter, and then what would be required to be shown as far as the standing requirement, the showing of harm on the individual perspective to justify the court involvement. But that is something that I think is on track for us to.
I think another thing would be like if we do have community involvement, because I feel like right now the biggest issue is that there isn't enough community involvement in advocacy elements, just because like I feel like there's for example, like I was speaking with Professor Stewart about this, the Friends of Split Oak, it's a wonderful website. And I think I would like, if I could also be involved in this, just because I've gotten real deep into this case. But I feel like if we had more, like right now with the CFX case going on, if we were actually shining a light on what's going on, I think it would bring more community involvement in that aspect, where community members can actually understand what's going on and what we can do to further that. So I think that's something that the next clinicians should really take forward into doing.
Meetings about this.
I believe that that's a good way into going into it, just because.
Because they're the ones who are doing the action.
Yeah, so there's really 3 different opportunities just about every month. So it's going to be the Orange County Commission meetings, the Osceola County Commission meetings, because even though they seem to have made up their mind, we still contend that it's the wrong decision and it's in violation of the contract, et cetera, et cetera. And then the CFX meeting. So all of those are every month.
I would contend that people have been so vocal that they amended their county constitution with 86%.
Yeah.
We have hours and hours and hours of testimony, public testimony, when the mayor only allows you to speak 1 minute. Like literally, what, 100 hours of public testimony over all these years?
At least. Well, every single time,
I guess-
every single time there's an opportunity, the room is packed.
Yeah.
I mean, this started back in 2019 on the CRC, when we had children come forward to us, speaking to us about, what does preservation mean? What
Even
does-
elementary schools took
And
on
these
a
are little
project.
kids, now they're adults.
Yeah, so another thing that we had discussed that we really hadn't had time to dig further into, was looking at engaging the property owners around where all of this is being developed. Because that's another thing that we don't think they're aware that all of this is going to happen, and that even in the places that have been developed, that you just bought these very expensive homes and you do realize that it's all going to be a parking lot pretty soon, So not only looking at the sort of public interest ways to go about it, but also looking at engaging people who have private interests in all of this development. That again was something that was sort of outside the scope. We were really just trying to get a handle on the petition, the eminent domain assertions, things like that. But the next step, because you're absolutely right. It's not for a lack of knowing. It's in the paper every single time it comes up. It's all over social media. The rooms are packed, everybody in their Split Oak t-shirts, and it's very obvious that people have an issue with this. It just keeps moving forward anyway. So that's the next step, is looking at who else can we engage.
That's very,
There's been no, our big issue here is that there's no political will. And because there's no political will, and the county attorney is only answers to the mayor, there's no legal will, because they control, and they hired a crap attorney to defend this, who got fired from his previous job for not being able to win eminent domain cases. That's what they hired.
And that's what the students had covered really last semester, was looking at what can be done. And ultimately, it comes down to Orange County asserting its rights, and it doesn't seem to be willing to do that. So even though every step of the way, it's either breaking a contract or illegal or unconstitutional or in violation of an ordinance, or every step of the way, there's a problem. But the harmed party has to do something, and they're not doing it.
Professor Margaret, could a private citizen sue and say, I'm suing you for failure to protect my land, our land, public land? Like, is there such a?
So, and that's what they were talking about in terms of, that's our plan to look into the next portion of it to see. So yeah, that's what we were talking about in terms of the assertion, is that, yeah, the government, you're not doing your job, and as the citizens, we're.
Somebody, a member of the public or a class action suit.
And that's what we need to look into, is what are the procedures there in order to assert that? Because as the students were explaining, the issue that we're gonna run into is the injury and the causation.
And even failure to protect money, right? Bonds and things that the public are on record have to pay.
Yeah, that was something I started looking into, and I didn't really get very far because I was unable to find anything where bondholders actually did have standing to sue it. Actually, everything actually kind of looked the opposite of that. But that's why I kind of talked about, it's kind of a novel idea that I just came up with. But if per the contractual terms, and we know that the contract almost doesn't even matter at this point, but per the contractual terms, if they do not restore the land, those bonds are, in meaning what they would do to restore is, right, Professor Stewart, they'd just find another piece of land somewhere else and designate that. But if they don't do that, then those bonds may lose their tax exempt status. And so that the reason I was looking into the bonds was just because it's money. And usually once you start getting the money involved, then people start actually moving. So I think that would be a good thing for next semester to actually fully hash out. Well, it's like various banks, but I think it's whoever the banks issued the bonds to, and I didn't get that far until.
Should we approach the banks, the financial institutions, and make our concerns to them? Because financially, I think this is where environmentalists always kind of fall apart. We need to attack the money.
Yeah, that's why I started looking into that.
So we got to start attacking the economic side of this and saying that,
yeah,
this money is bad money. It's going to go. Because CFX is totally a disconnected organization to our community. They're not from this area. They have representatives, but they don't have vote majority. So these people are putting roads wherever they want based on the development pressures, not from the citizens' point of view, because none of these roads are supportive of any of us living in this community. They're for the future development. And that's what this new road is for. It's not for anyone that lives there now. The cows don't need a car. You'll go into the slaughterhouse.
Yeah, I agree.
Eugene, tonight wasn't grim enough.
That's what the Mormons do. The Mormons are all about money.
Any other
That's what the
questions?
code is. Any other questions?
Yeah, can we go to the borrow pit now?
Well, yeah, the borrow pit.
Okay, so you said, and this is great work, all of it. Y'all done a fantastic job. Ton of information. Thank you. Okay, James Mead is obviously the scum of the earth.
Yeah.
But you said that EPA can order a stop motion or whatever. Motion to reset.
What does that mean? Yeah. It was in the timeline. It was the second to last item where James Mead or agriculture Agricultural Fuel Corporation has filed a motion to reset, but we didn't know what reset meant.
So it would ask the court to reschedule the previous
Oh.
scheduled hearing.
I see. So in that one, that is actually up for oral argument on appeal in that case. And his company has asked the appellate court at the hearing. So that's just a note that in the time. Currently set for,
Push it back a time limit? Is that?
yeah, he's just trying to reschedule from June 3rd and get more time. Yeah, he's pushing it back. He's delaying the argument, which that goes in what he did in the underlying case where fact discovery deadlines and court finally did set it.
Okay, so that slide that you have, it had the timeline and all of the hearings and the appeal and the appeal and the appeal. That's how it's delayed. It's the perfect delay tactic.
But he's expert.
We need to get that slide and take it to the judges and to the court and say, look, this has got to stop. You're letting this man
May I ask a question?
water and just, you know.
Mary, let me ask a question on this. You have a patent out there that he supposedly has a patent. It talks about how he is going to create an anaerobic situation. And based on what you said is he's burning this log stuff, which is unstable as they break down. And then he's going to cap it with topsoil. That's not encapsulation of an anaerobic situation. So should we ask the county to go do a test well, every single pit, to actually test it in an anaerobic situation and see if this is true? Because when, for example, the dump that we have just south of us is encapsulated. It has fabric and layers of clay, and it's a very engineered product to make sure. And there's monitoring wells around the whole thing because it does leak. So the question is, does this thing actually work based on his patent? And I think we should have the right to go out there and test it without his patent ability to say no.
Yeah, absolutely. That was one of the things that we explored is what authority and other actors have to go out and regulate. Even though the FD currently charged and involved in that underlying litigation, the county absolutely does have the authority on the books with ordinances to regulate borrow pit operations. The problem is exactly what the FD is running into is that this patent and this process, he's claiming exemption under the EPA standards and saying that the FD does not have authority over these processes, materials, because it is exempted under a specific chapter in the EPA regulatory that would exempt him and include that material process. However, there are, again, you follow the line of definition down, it's exactly to that point. If it doesn't work, is it actually accepted under the statute? And that is the question. The county is perfectly suited to go in and be the actor to say, we can regulate borrow pits. You are not currently permitted for these operations, and assert their authority. And if they're capable, and I don't know as far as and what they would be able to do to go ahead and what the materials are, because that is part of the issue. But if that is something that is within to uncover that information and prosecute this, even if they do get to a point ultimately challenged by him, then they have more information that the FD doesn't have, and that they're not as readily going out and getting involved in. So they're not able to get that except through discovery, which, as you guys all mentioned, actively evades any sort of discovery, any sort of action taken. So to the extent that the county can step in and say, we're putting our hat in the ring here, this is what we have to do, and if it's possible, the material, that would be the next step. Or then FD discovery, bringing it to the possible fix
mean, he should have to prove to us that his theoretical patent that he has actually works. And the way that you describe it, granted, high level, from my engineering background, ain't gonna work.
Concerning, dialing back to science and getting to the simple stuff. The water, the damage is flowing into Seminole County. So what recourse does Seminole County have for something where the problem is originating in Orange, but it's doing actual harm in Seminole County as well? Is there an aspect of that we can exploit?
I mean, that's something that we can explore. I don't think about it as an effective. One of the big issues, finding harm, actually, identifying what that is. It's in the rivers, track it. And again, bringing that action, enforce, cover what that might be.
Otherwise, we're just victims with no recourse.
But that's old English law. I mean, you can't harm downriver. And that's exactly what we're doing in Seminole County for harming. So their county commissioner could make an ask of our county commission and embarrassing our county commission to actually
think there's been communication already.
I've been asking Seminole to do that. Like, I would say, can you send me a nasty letter?
I mean,
Say,
maybe
do
we
something?
and the league needed
Please.
to go speak one-on-one to commissioners.
Let's do that.
We
Yes.
need to speak to the commission, the Seminole County Commission directly as a league.
Bob
I think.
Delarey, I guess, would be my first,
Yeah. And
He's
that's
aware,
his
he's
district.
aware of it.
all right,
Step one.
gonna raise trouble.
Politics, baby, we gotta turn on the power. Heat.
Just so you know, I met with him and his, when you talk about how deep he goes, he says that his patent doesn't, because there's groundwater contamination that the state found in that case. And he's saying, that's not my groundwater contamination because he's digging below the aquifer.
I can't.
That's what he says.
That's bullshit.
And then,
Excuse me.
and that there's Indian canoes that are 10,000 years old in the ground that are not decayed, and therefore his patent works. And I'm like, what?
What the hell is he speaking? He's smoking some crap.
And that's a part of it too. And that's, I think, also why we looked at the federal level is because those are the statutes under which exemption. So that might be something that also actors would be willing to have the, have that defining is or isn't under the statute. That would be a question.
Okay, I'm just confused on two cases on the I-4 dioxane. Yeah, what is it? One for dioxane.
It's good stuff I had you.
There's two cases, general dynamics. And so one is the city of Sanford and one is the federal government. Is this not the same case? No.
So the city of Sanford brought, with regard to the damage and how they could get money related to the damage that was brought to the citizens of the city of Sanford. The second case is brought by the EPA, and that was for remedial measures as far as like cleaning it up and making sure that it's cleaned up each year. So it technically closed, but they will review it once a year.
I have one, maybe a suggestion for the next semester. When you were talking about the floodplain plan in Seminole County, there's an aspect, I think, of environmental justice in it. If you started deep diving into where things are happening and how, would that be something you guys could look into? Okay.
Great job. Really interesting, really interesting presentations. They've got overwhelmed, and that's a good thing.
The good thing is that you will get the slides, so you'll be able to look back at every.
Hi, you guys. I sit on the county Commission and I was a professor at UCF. So first and foremost, I want to say thank you to Professor Margaret, because you guys didn't get that good by yourself. And then I just want to say, you know, there's a lot of really, really good attorneys out there that are advocating for, I believe, the wrong causes, because they're paid very well to advocate for, you know, profit over planet, basically. And I feel really, you know, as a teacher myself, I feel real hopeful to see that the next generation of attorneys coming out of Berry Law, they care deeply and passionately about the environment and just simply kind of fighting the good fight. And I've been very, you know, I've been frustrated up until this point that I can't get the legal will or political will out of the board to do something about an illegal borrow pit or a forest that is clearly winnable if we want to win. And I hope you guys come out of college, but law school, and that you fight the badass fights that nobody else wants to pick up. You know, I hope you do it, because we need more attorneys that are advocating, you know, for the benefit of our environment over the profit of developers' pockets. So thank you for all that you did, and I feel hopeful and even further frustrated that I can't get political and legal will at the board.
I'm wondering if any of you all on the panel right now are planning to stay in Central Florida? And are you planning to, how many of you are? And are any of you should have made better notes, planning to stay in environmental law?
As a passion project, yes.
Yes. Tyrese, you said you were going, but you're not staying in Central Florida?
I don't know.
No.
He's undecided.
You're always undecided.
It's a great place
Well,
to
I'll tell you
live.
what, join the League of Women Voters and make yourself known.
And then run for office.
Really, there you go. There's your future right there. You got it.
All of you.
So the rest of you who are staying here locally are planning to practice law in those other fields that you love. Well, just champion the environment every chance you get, okay? That's what we need champions. That was an excellent.
Thank you all for the opportunity and for coming
Thank you
to
for your
listen to
time.
us.
All the work that they've been doing. We're really happy on it. So you will be getting the full memos in the coming weeks. They do have a few more weeks to finalize that. And as soon as all of this processes, I'll send out the videos and slides so they
It's really important to us that we have that information going into the future and tracking it into the past. And we appreciate that a lot.
Thank you everyone for joining us on Monday. No.